Hello there, my dear listener. I am a student of law, Cameron Hayden, and today we're here to talk about contract law, more specifically breach of contract and the relationship between Victorian Laundry and Parsons. Now, these are two real big authorities, and I hope you don't mind if I put in some breaks now and again. Maybe to listen to music. I feel like it's too boring if you just had my dulcet tones this whole way through. Alright. Now, the first thing that we really need to talk about in this situation is an essay-styled question, because you know I absolutely love the opportunity to talk about the essays I've written and how they can help us get a better result. I feel like just about every essay that we go through is something set out in this sort of formatted discussion template. So if you know how to talk the talk, it helps to make you walk the walk when you write an essay. So always write an essay with the idea that this is something that you might have to talk to somebody about. In any case, so here's our discussion point, right? Here's the question. In the 20th century, the principal issue of controversy was the relationship between the decision of the Court of Appeal in Victorian Laundry (Windsor) and Newman Industries 1949 and Parsons Livestock Limited and Utterly Ingram and Co. Limited 1978. The tension between these two remains largely unresolved. From looking in depth at the common law, it is easy to see how McKendrick, because this comes out of the McKendrick book, came to such a conclusion, as even prior to the Victorian case, it was clear that a disparity was emerging in this area of the law. With that said, McKendrick does go on to highlight that some aspects of contract law in relation to remoteness tests are certain. First and foremost, in terms of the test of causation, there is no division made between an intentional, careless, or inadvertent breach. Intentional. Catch me there. Inadvertent breach of contract. This is quite in opposition to the more established distinctions that exist within its neighbour field of law, torts. So in torts, there is a set of law in regards to your carelessness when you breach contract. I mean, that's basically basic negligence. But that doesn't exist in the land of contract. It's very different. Now, with no distinction, the test of causation follows the ordinary rules of proof, whereby the claimant is under an obligation to prove the defendant breached the terms of contract in such a way as to result in a loss. That the type of loss is deserving of compensation, and that the loss is not too remote. With a remedy awarding damages, i.e. money, to the injured party in such a manner as to place them in a position they would have reached had the contract been fulfilled. So you see, the idea we're coming to here with the test of causation and the remedy to that is that we look at, are you really to blame for the breach of contract? If you are, it is your duty to put the other party in such a position that it would have been as if the contract was fulfilled, as if nothing had gone wrong. This is quite important because if you could get out of that, it means you've just saved a lot of money. So usually the idea being to encourage you really to ensure you most definitely do the job. Now, where we got that whole idea of the type of loss deserving compensation, the loss must not be too remote, that comes from the Chaplin case 1911, and the idea of rewarding an award of damages so as to put you in a position as if the contract had been fulfilled, that comes from the Robinson case 1848 and was repeated again in the Gramophone case 1909. So those were some of the earliest sort of representations of that sort of law. Now, further, it is clear that the recoverability of damages is not dependent upon the nature of the loss suffered. so much as whether the parties had the knowledge or were in contemplation of loss when entering into the contract, with a particular focus upon the party committing the breach. The Parsons case did attempt to categorise between cases of contemplation and actual knowledge. However, this train of thought has lost momentum over consecutive cases. So the sort of division they were trying to create has been worn away in later cases as they've focused back on the middle ground. With the two elements of clarity made clear, there will be a return to the tensions between Victoria and Parsons. Now, to understand the tension between them, it is necessary to come to grips with the situation which these cases took place in. So keep in mind what we've just spoken about is where there is clarity. Now we're going into areas of confusion within this part of the law. Okay. At the time of the Victoria case, the influence of traditional juries was waning, and the judges in Victoria, principally Lord Asquith, decided it was time to bring together a set of guiding principles to aid both the lower courts and the jury towards making a more reasoned decision, and to scale back some of the expansionist approaches the judiciary was taking from the case of Hadley and Baxendale. Now, what you need to understand here is that jury was really strongly important in how judiciaries run in the early parts of the law, probably the periods prior to 1950. However, it started to become clear that judges, with the expansion of the population, there'll be more decisions decided by judges without juries, and even among the juries with their greater diversity, you don't want the inconsistencies that can sometimes emerge from jury cases. For example, if a jury decides to go one way which is different from how a previous jury has, we lose the idea of precedent, right? So the concept that Victoria was trying to get across was to create a set of these guiding principles so that juries can make more or less the same sort of informed decision on the same reasonings, and that would give a certainty within the law. Alright? And one of the problems of Hadley and Baxendale was that both judges and juries were going in very different directions with the law. They were interpreting it more or less in a very flexible format, in their own format, and this had created quite a deal of uncertainty as the judges Lord Asquith gets to in his coverage. But anyway, now, given the Victoria case was more of a codification of the pre-existing law on the matter, it is written in such a way as to give credence to certain judicial choices. So, prior to Victoria, there was a landmark authority in Hadley and Baxendale, 1854. In the case, the defendant was a carrier who had been tasked with the delivery of a crankshaft, unaware of its value to the company whom hired him. The carrier unfortunately made the delivery late, and in doing so gave rise to the question of what damages, if any, were owed in the circumstances. So keep in mind, this is a carrier, so this is not like a business-to-business transaction. This is your middleman in between who is delivering an item. He doesn't necessarily know its importance, and he's delivered it late. And in that case, the late delivery led to a loss of profits because the mill in question remained closed for an extended period of time. Anyway, in this case, the Hadley case, this was what was set out. So, to discover what was needed, Alderson set out what has commonly become the Hadley principles, which are 1. For a party to be liable for a breach of contract which arose naturally in the ordinary course of things, so long as the breach could be reasonably supposed to have been in contemplation of the parties at the time contracted together. Okay, so basically it was just one principle came out of it. This idea of the breach must arise naturally, and it must come from the ordinary course of things. And you could it must be in the contemplation of both the parties. So that can be taken in a very limited concept, a very limited view, because it means that you have to somehow say that both parties thought that there were ways it could be breached, and this may happen to be one of them. So, yet without specific knowledge, it shall be assumed the contract breaker only contemplated the general loss of profit, not any special arrangements, without being made aware, and so should be held liable to pay damages for the former. Again, this is another problem where they put down to, because our carrier is not a special person, shall we say, he's not a skilled businessman, he's just a delivery guy. This is not his field of expertise. He does not understand the value of the crankshaft. He has not been informed of the value of the crankshaft, and so he should only be held liable for a general loss of profit arising from delivering something late, and not the additional loss of profit. Now, what that tends to mean is, if we took it the other way, if they did have that special knowledge, there is a good chance they will be expected to make additional payments. And that's what we get onto in later stages of the law. So in the years that were to come until the Victorian case, Hadley was treated at first as merely an authority on the process for which to recover damages, as discussed in the case of Bent's Graphics by Hodson, Lord Justice, whom describes the language as comprising the basic principles of the test of remoteness, using the Sale of Goods Act 1979 under section 52, which impliedly accepts the second part of Hadley's test as evidence of this. What's important is Hadley is more or less, depending on interpretations, you can treat Hadley as a two-part test or a one-part test, but we'll come to that later. There is little point in disagreeing with the learned judge. However, Hadley was much more than that, as Hadley also provided for an exclusionary clause for indirect and consequential loss, with the first limb of test forming the natural loss or direct loss, and the second limb forming the indirect loss. So what we're getting here is, if you were to interpret Hadley in two stages, you could say the first part deals with indirect and consequential loss. Well, we're saying that, but the first part deals with the natural loss arising, your direct loss, the clearly stated loss, and then the second one, indirect. So loss of profits, for example, might be considered an indirect loss, because, you know, that's not something that's primarily to do with the trade going on right now. It's something that arises as a result of the trade not going through on time. Anyway, one of the matters which enter into tension within the Victoria case relates to just these two limbs of loss from Hadley. Yet Hadley was not the only authority of the time which Victoria wished to reconcile. Indeed, following on from Hadley, there was the case of British Columbia Saw Mills, Hotel Services Limited, and Hilton. Oh wait, no, sorry. Saw Mills and Nettleship, 1868. Now, which sought to set out one method with which to prove plaintiffs had knowledge of the importance of a timely arrival communicated to them. Basically, if you told someone, look, we really need you to turn up on this time, it was considered, was that sort of language sufficient enough to give you the special knowledge, you know, that this needs to be arriving here now. So Justice Willett believed this was possible as long as the plaintiff made the defendant aware that under such circumstances the defendant accepts the responsibility for a special loss from the person to which he contracted with. And that's we take that from the Sawmill case. Equally in Horn, so this is Horn and Midland Railway and Co. 1873, it was found a notice could amount to acceptance of such a responsibility for liability. One case, Simpson and London and North Western Railway Co. 1876, took this a step further in finding mere words of urgency, the words being must be at Newcastle on Monday certain as sufficient enough to accept liability. So what we're starting to get here is this real broadening of the concept of liability, of acceptance for this indirect loss, that being aware that there is a deadline date that you have to get this stuff there for, it is some way an acceptance of the losses you don't necessarily know to happen or exist as a result. And Horn and Simpson, Horn just basically says, if you've been given a notice, that's enough. And in Simpson, it was the words that are told to you. So with Hadley being interpreted so widely by the lower courts and on acceptance of special loss, the remoteness test's limitation was becoming more remote in and of itself. So the case of Victorian Laundry emerges with Asquith, Lord Justice, who identifies that within this area of breach of contract, cases fall between the two extremes: non-delivery and delayed delivery. Non-delivery/delayed delivery of a clearly profit-making cartel or chattel, including merchants, passengers, special goods of these sorts. The law is often in favour of giving a loss of profit judgment as it is clear from the parties involved the results of a breach. So if you've got to get a merchant from point A to point B, probably with his goods, it's fairly obvious if you arrive late, they're going to make a loss of profit because they need to get there on time to do the trade. Passengers, it's the same sort of deal, and special goods, all these sort of things, there's a reason why they have to get there at a certain time because, it's special, it's very obvious, there's a lot of empirical law to support that. In contract, they've tended to give a loss of profit result in these cases. However, on the other side of the scale falls the cases which are particularly difficult to reconcile with. Cases where the breaching party is someone without special knowledge and is ill-informed of the worth of goods, such as a carrier. Look at Hadley. Asquith puts the issue in such cases down to not a different principle being applied, but more that the same principle applied to a different set of circumstances gives a different result. And this comes from Asquith himself. So in Victorian Laundry, Asquith seeks to combine the authorities of Hadley and Baxendale, British Columbia Sawmills, and Corey and Thames Iron Works Company. In the latter case of Corey, it revolved around the failure to deliver a unique hull after 6 months' delay, which caused substantial losses to the buyer. The judge in this case, one Cockburn CJ, felt that to apply Hadley, it had been written would lead to a most mischievous consequence, and as such should not be applied. Essentially, in that case, the matter was so massive, the loss was so great, that for whatever reason the judge decided not to hold the other party liable, and really interpreted Hadley in a very different way than perhaps it could have been, just to avoid the sort of injustice. Because I believe the delay was something that no one could have foreseen and was a result of a situation outside the gentleman's hands. Basically, there was a war going on in the area, and for that reason they weren't able to transport the hull across the sea. And this is something that no party could have ever foreseen when they were contracting into this. It was a very big thing. And what the Cockburn was saying is, if you'd followed Hadley stringently, then the party that failed to deliver on time would be held fully liable for essentially something that's completely out of their hands. They can't stop a war by themselves just to deliver a hull, and the justice in this case was saying, well, basically he more or less was distinguishing without saying the words distinguish. Anyway, so in codifying this area of the law, Victoria set out its own principles, which were to be a clarification of the rules set out in Hadley to prevent injustice that it would have led to in Corey, and strip back some of the unreasonableness that had emerged from cases like British Columbia Sawmills, which, if followed down to the route of Simpson, might have led to contracting parties being liable for any loss or profit, despite the remoteness. Now remember, this is in Simpson, it was really quite remote, And those words that he said, didn't get across anything in particular. It's like I say to someone, I need you to deliver a computer. I need it for Monday. I might not actually need it for Monday. I could be fine until Wednesday. But because I said I need it for Monday, that is being implied as sufficient to give you a special knowledge, which is really not what Hadley was trying to do. And that's exactly what Victoria was talking about, that they wanted to scale back this sort of really broad liability that almost everyone could be liable for just about anything, if for any reason, essentially. So, to prevent this, Victoria set out the rules that, 1, although the purpose of damages is to return a party whose rights had been violated into the same position so as to be reasonably whole, so as money can do as if rights had been observed. So, like we were saying earlier, although generally it's the principle of contract law that if there is a breach, you give a person money so that it's as if the whole thing had been dealt with. If this had been relentlessly pursued, this is a quote here, relentlessly pursued, this would enable the violated to gain a complete indemnity to any loss sustained, no matter how remote or unpredictable, and so without limits is too harsh. Just think back to the Corey case. For what Victoria's saying, that party who were in breach because of a blockade in war, you can't get your stuff through a blockade without smuggling it. That's illegal anyway. That stopped them. War stopped them. But if you had followed Hadley in the same way Simpson was going, that situation is a really remote situation that happened in Corey, but you would have held one of the parties liable. And that's not what Victoria wants at all. So they said, we can't have this idea that you've got to return them to as if the thing had been fulfilled. That's way too broad at the moment. Let's try and stream down it a bit. Let's make this remoteness thing a thing. So, thus, as a limiter, this is the second thing we get from the Victoria case, the second point. The aggrieved party to a contractual breach can only claim a recovery of losses which are reasonably foreseeable at the time of the contract to be a result of the breach, with 3, reasonable foreseeability, dependent upon the knowledge held by the parties at the time, particularly the knowledge held by the one in breach of the contract. As such, 4, knowledge forms 2 kinds, imputed and actual. So now we're getting some real limitations brought in and some beefing up of remoteness. Now we've got to have this reasonable foreseeability aspect, and we've got this imputing of knowledge and this actual knowledge. What we mean by imputing is we're saying you're basically implying something, and could they understand from your implication what you're saying? Or in the other sense, did you actually tell them, I need to get it on this day. If we do not get it by this day, there will be about £1 million worth of profit lost for every day we don't get it, and you will be liable for that. That's actual. You're telling them we need it on this day. There's a special circumstance beyond just the normal needs of delivery, and you will be liable. Imputed is if you were talking about that same stuff but not saying specifically that guy's liable. You're just saying more or less, we need to get it on time for this day. I am a special business. In Victorian Laundry, what you've got to understand is in that case, they were expanding their laundry business boiler, and they had a special contract with the military, I believe, to basically launder clothes or something like that, something government-y. And this is a unique contract, and had the boiler arrived on time, they would have been able to deal with that contract as well as the expanded business they had. Now, as far as the carrier was concerned, they were aware that Victorian Laundries is a laundry, so by not getting the boiler on time, you could, it could be imputed, that there would be a general loss of profits on ordinary laundry transactions. What you couldn't have been aware of without special knowledge or considerations or awareness is this contract with the military that the laundrette had. Had the other party been aware of that, that could be considered our special loss of profit, the second stream. Anyway, so Asquith then explains how the reasonable person understands ordinary course of things, and how, by breaching a contract, what loss is likely to be a liable result within the ordinary course. He placed this as the focus of the first limb of Hadley. In this, Asquith is discussing what could be in the modern time, termed the normal course of practice. That is to say, if a fireman is hired to put out a fire and they fail to do so, they will likely be liable as a result for whatever the fire consumes. Consuming whatever is burning nearby, right? So you figure, to a fireman, someone says, you've got to come down here, you've got to put out this fire. You get to the scene, but you don't put out the fire. What this is essentially saying is, as in, like, you did nothing when you got to the scene. You didn't try to put out the fire. Figure it like that. And what it's saying is that would be considered the ordinary course of things. Your duty is to put out a fire. So if you came down, you should put out fire. Now, Asquith also discusses situations which fall outside the ordinary course of things, which require special circumstances and have attached an additional loss. For these situations, he admonishes the need for a second limb of Hadley, further lamenting that for the contract breaker to be liable, they need not have asked themselves what loss is liable from the breach, which is what we were getting across from the earlier case law that was building up. Instead, as parties contracting parties often consider not the result of failure, but the advent of a successful performance. So what it's saying there is it's very hard to imply the businesses were thinking about all the ways that our contract can fail, because ultimately they want it to succeed. They get the greatest bonus from the contract being fulfilled, so why would they think about the ways that it cannot be fulfilled? That's what the judge in this case is trying to say. He's saying if you think on that mindset, then you're going to need a different test, rather than one saying, oh, were they both contemplating at the time that something could go wrong? You need to have something that focuses more on their actions. So instead, it would suffice if being a reasonable person, had they considered it, the loss was liable to result as either a serious possibility within his mind or a real danger, so that the result action was liable for the result, or in common words, on the cards. Now, there's a later discussion about just the terming like on the card, but how I am choosing to interpret Asquith in this case, in his serious possibility, a real danger, and on the card, I think of it like this, right? You got 7 cards in your hand. I'm not talking about taking cards out the deck, which is what the judges later refers to. I think of it more in terms of, you're playing poker or whatever it is. You've got your hand ready. You've got your cards, so you could play the first card, and that's like your winning card. But equally, there are other cards that you could play, and things can go wrong. Like if you had in your hand a king and a jack, in best case scenario, you want a royal flush on the table. But there is every expectation that you could get a 3 of a kind, like 3 lots of jacks or whatever. That's a winning hand. But equally, your opposition could get something else, or there could be complete trash on the table. And that's what this is kind of getting at. The idea that, can they foresee is there any obvious kind of breaches that could occur? So we're not talking about the wartime thing in Corey where there's a blockade going on. That's not an obvious thing you could foresee. But saying the M25 could have delays, if you're not from Britain, you won't understand that. So let's just say if you're in America, the Spaghetti Junction, whatever it is, basically traffic jams are a bit more predictable because they are pretty common in our line of duty. So a lot of suppliers will expect you and buyers to take into consideration there could be these sort of circumstances, right? Especially if there are, say, road closures. There will be an expectation that a supplier will look into road closures and try to avoid them in the ordinary course of business. I think that sort of consideration is what the judge means by on the cards. Anyway, Asquith justifies his decision as stating that the case of Corey misinterpreted Hadley's first limb. Although, as Cockburn acknowledges, this decision was likely to avoid a gross mischievousness, Asquith then removes Corey's use of necessity to result and replaces it with liable or likely to result in a loss of business. Asquith then discusses how, knowing the basic intention that the boiler was needed to extend the business, is clear enough language without further details as to ascertain acceptance for loss. However, they also remark that where the loss falls outside the usual realms of imagination, such as lucrative contracts, that is something which the carrier needs to be made aware of to be liable. Further, whether the part being delivered forms the whole or only part seems irrelevant. And that's one of the things that Corey went over. I think Corey was talking about you need to make a distinction as to whether whatever's turning up is a whole package that you need or if it's just a part, because the part they're saying, during that case it was about a piece of a ship, whereas in other cases it could be the entire product. Don't know how that fits into cases like the crankshaft one, Hadley itself. But Victoria wasn't even considered that. He just said, you know what, it's not about whatever item you're getting. That doesn't really matter. It's about the end result and the awareness of the parties at the time and how you make them aware. So basically, it's a lot easier to claim for a loss of profit on the ordinary business than it is to claim on a loss of profit for some special situation that has occurred. Anyway, as is clear at this stage, Victorian Laundry has its own way of interpreting the Hadley test of remoteness, so as to remove much of the risk of liability which was inherent in an unrestrained, unclear form. It has become amply clear or amply certain Victoria led to its own uncertainties, which were discussed in the case of Heron 2. Now, I think we're going to listen to some music now. I think that's really what we need at this point in time. So we're just gonna hold out, and then when you come back, we're gonna keep talking about the uncertainty that arose out of the Victoria case. So go toilet. Sorry, this is your chance. This is the interval. back. I hope you were able to use your break rather wisely. It's always wonderful to listen to piano music to break up our study discussion period. You know, sometimes we let the brain run a bit too long and we need to just sit back and take in what has been said and really come to terms with the information to allow it to solidify in our minds, and of course, you know, take those rest periods, always important. Maybe get something to eat. I just had a handful of blueberries, some mint tea, and a gander around the garden. Good to recovery. A little bit of energy and exercise gets us always back in the game. Now, where do we leave off? Well, just take some mint tea before we continue. We were talking about the uncertainties that came out. As we all know, earlier on we were saying that Victorian Laundry came along to bring certainty to the uncertain. It came to change the broad interpretations that had arose out of the earlier case of Hadley and Baxendale, and to really limit the risk of liability with a new, more robust understanding of remoteness. And there was a lot of terminology used, such as serious possibility, real danger, liable, and on the cards to help in understanding this area. Unfortunately, this causes a problem which is highlighted in the Heron case. Now, just so you know, the Heron case is considered to some extent really a very wordy case, and there's criticisms of it. I think Kufus is also quite heavily criticised for its verbal lingualism. Try not to get too buried in those sorts of cases, otherwise you'll get a greater understanding of the English language and a lower understanding of the law, because you will be greatly confused by them in any regard. So in the Heron case, it revolves around how a shipment's delay in arriving by 1 day resulted in a substantial loss of profits on the cargo of sugar, as the available market crashed dramatically within the space of the day. In discussing whether the market crash is too remote a consideration by the judges Lord Reed, Lord Morris, Lord Hodson, Lord Pearce, and Lord Upjohn all make clear their view, dicta of Victoria. What you've got to keep in mind is the sugar shipment we're talking about. The drop was a few pounds, but to get that understanding in our sense now, because the pound is not worth the same as it used to be, imagine you had a ship full of sugar. So let's just say, all right, you've got £1 million in apricots. £1 million of apricots. The market in China that you're selling it to really values apricots right now, and it costs, I don't know, 1.5 million at the moment over there. So you're going to make a lot of money if you can get it there on Monday. Unfortunately, you end up getting there on Tuesday, and in the space of a day, it has dropped in value by £200,000. Now, that's the sort of loss we're talking about when we're talking about the Heron case. Alright, so massive amounts of loss. Right? It's really substantial on everything that's been brought. So, in the dicta for Victoria, what we hear is Lord Reed begins by focusing on the use of the word liable. He considers it as a vague term, which he interprets as meant to mean a very improbable result. So that's already quite a confusing interpretation of liable. I mean, how can you say someone is liable for a result and then say, oh, actually that word means it's very improbable to result? It's not really computing in my mind anyway. So going on to take further issue, he takes issue with the words serious possibility, real danger, and on the cards. He considers them to be too broad to allow for any unthinkable result to be liable. So now he's starting to say he's really highlighting the issue that they even had in Victoria by saying, oh, when you say those words, now we're more or less saying, oh, everything counts as liability. I'm not entirely sure that's what Asquith was going for, but that's how Reed interpreted it as. So Reed then contrasts such a wide scope with the result of the Wagon case. This is the Wagon case 1961. And in that case, the defendant was not found liable for a highly unlikely fire which burned down the building in question. So it was something like a warehouse. Do not catch me on the facts. If I'm inventing facts, you should have read the case. You should always read the case. Don't always rely on your radio host. But warehouse building, whatever the situation was, there was some sort of fire. I think it was a fault in a fridge or something. This is starting to sound like the that tower fire not so long ago. But anyway, basically something really unforeseeable happened, caused the building to burn down, and they are saying, is the bloke in question liable for it? And the decision was basically no, it's really remote. So they took the question of taking on the cards. In its most broadest reading, they interpret it as the defendant should have been found liable. So somehow they say even the incredibly unlikely risk of the building burning down, because faults happen, it is considered a fire might occur. So you should be held liable for that. That's the idea of on the cards. It's more or less, I really don't like the way Lord Reed chose to interpret the words on the cards. I think it's really, they're being picky with wording, and they're going really beyond the true meaning that Asquith was getting across. Asquith just used it as a way of better explaining his earlier points, so you had to give it that sort of context. I don't think Lord Reed gave it that sort of context. However, Reed worries that if taken in its broadest reading, it creates a large gulf between what is not unlikely and what is quite likely. So he's saying, with on the cards, everything is on the cards. He's taking it in that term. When you say, it's all on the cards, guys, anything can happen. I think that very much this bloke saying, there's only so many options you have available. You should be considering the most common options. I think that's how Asquith wanted it to be perceived. Lord Reed is saying, well, certain judges, and no doubt this is a crack at the fact that even in Victorian Laundry they're talking about how lower courts interpreted the statutes and the precedent. So in this sense, Reed is basically going, you know what, we need to really stream down the wording to make it even more clearer. So with that said, Lord Reed finds opposition in the use of vocabulary, because he then says it means it's there to be a means to help give guidance on how to proceed, and Hodson points out the phrasing liable to result while rejecting likelihood. He takes the phrasing of liable to result, and he takes the words likelihood, and he thinks liable to result is a better phrasing of the word likelihood. He feels that it would require, for likelihood to be the case, you need to have an almost near absolute belief something will occur. So think of that again. Likelihood, he's trying to say that's just about, we're talking 90% to 100, it's probably going to happen. Again, maybe likelihood was meant to be a little bit more flexible than that. Maybe it was about 60%. This is something that could happen. I think that's what they were going for. That's the problem with the English language. No matter how you say a word, it's how the individual chooses to perceive how it's meant to be said. That's why we try to use a lot of words to describe one thing, especially in the court, because the idea is the more you have, you'll be like, oh, I can basically compare and get a real idea of what you're going for. Anyway, Lord Pearce, by comparison, accepts the wording of Asquith, Court Justice, while rejecting the words on the cards. So now we've got Lord Pearce doesn't entirely understand what the words on the cards mean. So he just says, you know what, just get rid of it. It's not really an effective means of adding to your earlier explanations. While this is going on, Lord Upjohn makes a most enlightened statement that the assessment of damages is not an exact science, and to what one judge or jury may appear to be a real danger will appear to another to be a serious possibility. So what we're getting here is Lord Upjohn is saying, let's not get bogged down on the choice of the words. The words are not important. The idea is that Asquith in Victoria was just trying to give people multiple ways to interpret the language because he thought there was a need for it. You can't just tell people one set of wording and expect everyone to understand it the same way. He was giving variety so that a jury with maybe different backgrounds could come together on a similar understanding. So in essence, the justices in Heron 2 sought to narrow down Victoria's concept of possibilities so that a judge or jury could make an informed choice as to the liability of the contract breaker. Okay? And we can take that interpretation from Lord Hoffman in his article for the Edinburgh Law Review, The Achilles, Custom and Practice or Foreseeability, where it was done in 2010, and he talks about exactly this interpretation that Heron 2 has of Victoria. So, next we move on to put forward by Lord Denning in Parsons. This is the case of Parsons Livestock Limited and utterly Ingram. If you don't remember Parsons, the Livestock case, for the gods that be, remember pigs. Okay? Remember pigs, remember the word animal farm, whatever you want to remember. Just associate in your mind pigs, Parsons, and loss, right? Because what happens in Parsons is it's a case where there's a fault in the machine. The case was around how delivery of faulty goods with a minuscule defect. Just this led to 254 pigs dying and substantial loss for the plaintiffs. What we mean by this is livestock, like pigs, are fed food on a conveyor belt, very similar to how we feed chickens that are kept in factories. The trough, which would be holding the food, comes out of a distribution machine. What happened in this case was the gentleman ordered this distribution machine type thing, poured the food in there. Food was given to pigs. What they did not know was there was a really, really tiny defect in the machine that meant oxygen was getting into the distributor earlier than intended, and a lot of the product was going off much, much quicker. As a result of that, the pigs were being fed this really gone off food. Now, ordinarily that's okay. Pigs can handle a little bit of gone off food. But if we're talking really badly infected food, which was the case, then it just led to a mass amount of pigs dying, and the guy had to quickly quarantine them. But at this point it was really too late, and it's really an unfortunate situation. This case is also important in consumer contract if you ever get to that subject. Anyway, in setting out how to approach this case, we now have Lord Denning appear. So Lord Denning, our real astute judge, who, common sense approach judge, who pops up through a large amount of cases in this period that are empirical. Anyway, so we have Lord Denning appears, and as per his way, began to address the issue of remoteness within the law, making reference to Heron 2 that under the contractual test of remoteness, it is a matter of whether the reasonable man contemplates the consequences of the breach at the time of making the contract with a very substantial degree of probability, repeating much of the phrasing already discussed. Rather than deliberate upon whether the issue is one of contemplation or probability, which was the case in our earlier cases, Denning sees these more as a question in semantics. So he's going, probability, did it occur at the time? Why do we need to worry about this stuff? The situation happened. We don't need to worry about the words. We don't need to worry about the mindset of the people. We need to worry about the result. That's what Denning's trying to say. That's why he starts to work to split off. So he sees it semantics and finds it easier to go back to a distinction made by the academics in Hart and Horny. Hart Horror. I cannot say the name. Basically, it was a book called The Causations in the Law by a gentleman called Hart Horn. Namely, that there are cases where there has been no damage to persons or property only economic loss, like cases of loss of profit or loss of opportunity. And those were there, and those where there is actual injury done to a person, property, with insuring expenses, and Lord Denning tries to bring the two together. So what Denning's saying is we shouldn't split these cases based on contemplation. We shouldn't split them based on wording. Let's just split them based on what has happened. This is actually quite a lot closer to how tort operates. We should have these loss of profit cases where we're talking about money that just doesn't exist. You know, like we're trying to say, oh, had the crankshaft arrived at that mill in Hadley, we would have made so much money. Well, you didn't actually have the business at the end of the day, so you don't actually know what the result of not getting it is. That's a loss of profit case. In the situation of Parsons, we have a physical loss occurring. We have actual injury. We have 254 pigs dying as a result of the breach of contract. The contract being you must non-faulty goods, and faulty goods is what they got, and it led to the injury of, in effect, death of so many pigs. And that's where the loss came in. This was an actual loss. Anyway, with loss of profit cases, Denning believes Hadley, Victoria and Harrington should apply as all relate to some loss of profit and are adequate in dealing with them. So what he's saying now is, let's look at Hadley, let's look at Victoria, let's look at Harrington. These are all loss of profit cases. Let's just combine their approaches together and say, okay, that deals with loss of profits. He then goes on to say, by comparison, he feels that other classes of cases, the physical damages class, for that the bar, or what is reasonably foreseeable, should be lowered, like it is in tort, to what is slightly reasonably foreseeable. So now we're adding this additional word, it's going to have this additional meaning. So now we're saying, more or less, we're looking at, you know, is it on the peripherals? Could you probably have had a slight consideration that it might occur? And that's good enough for us. So Denning looks to cases like Wagon as evidence of this line of thinking. And that is generally that this area of law should coincide with the tort principles of what is now termed consumer contract law. Denning draws upon how Hughes, this is Hughes and Lord Advocate 1963, that's another case, and Simon and Pawson and Leaves Limited 1932, so a much earlier case there as well, how they were decided to prove that liability for physical damage can be assessed in this very same manner. So what Denning now wants is he wants contract law to go more in line with tort law, and his hope is, okay, if judges understand tort law and they understand contract law, then you don't have to teach them as much, and there's a lot more cohesion. You know, there's a lot more clarity in the law because everyone knows what we're going on about. Lord Scarman draws the same conclusion as Denning, in that there needs to be a distinction between tort and contract, that this distinction is largely a game of semantics, yet he agrees quite the opposite with the Heron and Victorian Laundry cases, that the best test is one of reasonable foreseeability and reasonable contemplation. Scarman believed that the real matter was whether the judges themselves had introduced common sense in identifying whether a party to the contract contemplated the serious possibility without inquiring after the presumed contemplation. So here again you can refer to the Sale of Goods Act, 1893, so it's a lot earlier Sale of Goods Act as well, so we have a lot of those. In this sense, Scarman perceived a serious possibility, not in terms of the probable belief of a result, but rather a matter of whether the reasonable person could reason their way through the logical steps of liability. That is to say, could they have given adequate consideration to the result? Now, what Professor Burrows notes on this matter is that Victoria makes a strong distinction from Parsons, as Parsons expands the scope of ordinary loss to include linked events, whereas in the Victoria case they would have likely distinguished between ordinary loss created from initial direct. So basically this is how we're choosing to interpret the Parsons case, had it been interpreted in line with Victoria rather than Parsons. So if it had been interpreted in line with Victoria, they might perceive the diarrhea of the pigs and the resulting E. coli outbreak as outside the ordinary course of things and the loss of profit. So what had happened in that case is the food troughs having dodgy food led to the pigs, having diarrhea. Very nasty business to talk about this, but pigs got diarrhea, and then from diarrhea that led to an E. coli outbreak. Now what Victoria might say is, okay, the machine being faulty led to the initial pigs getting sick. They should be liable for the pigs that got sick from the faulty machine, not for the ensuing illnesses that spread from those sick pigs to the others. Maybe that's outside the ordinary course of things, and that should be a loss of profit, and the former should be just an ordinary loss. But anyway, the tensions appear to continue in later cases like Brown. So this is Brown and KMR Services Limited, 1995. So we've quite a leap in time forward. In cases like Brown, it is distinguished that Victoria as a case focused upon indirect loss, while another case, Balfour, so this is Balfour BT Construction Limited and the Scottish Power plc, found that on a case of physical loss, that unawareness of an issue did fall outside the ordinary and follow Victoria rather than Parsons. So quite a different turn of events here. So now we see in the future that actually there was still this problem of, do we follow the Parsons approach or do we follow the Victoria approach? And they're quite divided on this. So the most modern landmark case on this matter is Transfield. This is Transfield Shipping Inc. and Mercator Shipping Inc., or the Achilles case, 2008. So in the Achilles case, attempts to reconcile the rules of Victoria and Parsons occurred. Interestingly, the case seems to follow initially the statement of Lord Upjohn in Heron 2, that it is necessary to consider the case beyond the words, as well as Victoria's idea that there are types and kinds of breach in determining damages, which might affect whether damages can be judged on market standards. And that comes from the Belzies and Belzies Telecom case, 2009. So it's a late interpretation of a slightly earlier case. However, it also moves away from all these authorities in a very particular fashion. It appears Transfield, or the Achilles case, adopts Lord Denning's proposed exclusion clauses as an exemption of damages resulting from a breach. Yet in other respects, Lord Hoffman follows the Victoria case, although he also adds the concept of assumed responsibility. Baroness Hale swiftly moves away from the talk of assumed responsibility that Hoffman brings up, of incorporating negligence and tort into contract for fear it would create a deus ex machina of the law, and that's the word she uses, and that's originally comes from the terming in Anico Renaissance Underwriting Limited and John Higgins, 2002. And what we're saying is, if we put contract and tort together, this amalgamation will create an entirely different product of the law, and they didn't really want that. It would basically be its own self-fulfilling prophecy, and the judges were trying to prevent that from happening. So, with that said, in the case of Sylvia, Transfield is explained as an amalgamation of the traditional view of Victoria and Parsons, but Parsons is only to be used in extraordinary cases where the market circumstances force the case to fall outside the usual remit, and that merely an extraordinary situation emerging from the ordinary course of things is enough to create an assumption of responsibility. Yet even with assumption, uncertainty over intention still remains. And further, it appears that in some jurisdictions like Singapore, that Hadley is considered to already incorporate the assumption of responsibility through the first limb of Hadley's Contemplation of the reasonable person, with knowledge of actor of the second limb. Now, you've got to keep this in mind, because obviously, while this is English and Welsh law we're talking about, it is the basis for a lot of systems internationally, and sometimes the judges do look at the decisions that have been made in international courts, because, of course, the courts in Hong Kong and the courts in Singapore, to some extent, do have English judges that work there from time to time. And for that reason, often in English and Welsh cases, we sometimes look at overseas jurisdictions to get a persuasive perspective on the law, a new idea about where to go and whether that's worth the choice. So that's why it's important now to see how this assumed responsibility has been basically accepted in Singapore, and whether the same interpretations will occur here in England. So now, before we get to the conclusion of sorts, I think it is important we have a little bit of time to listen to some music, just to clear our minds again, and then we can have those concluding thoughts and get straight back into things. Well, some absolutely wonderful music there. I do hope you had the time over the break to relax yourself a bit more, to get ready for my dulcet tones, and to prepare yourself for what will be the conclusion of this discussion on, relating to breach of contract and the cases of Victoria and Parsons. So, in conclusion, as it becomes apparent in the cases of Super Shield, that is Super Shield Limited and Siemens Building Technologies FE Limited, that's a 2010 case, and John Grimes, the John Grimes Partnership Limited Gubbins case 2013, so quite recent cases, as well as looking across the absolute plethora of cases from the last century, the 20th century, it is easy to see the truth of what McKendrick is indeed trying to say, as it would appear that Parsons sought to divide contract law between its more traditional roots and tort, whilst the Victoria case tried to limit liability by containing the law within a more narrow-minded traditional approach. And all modern attempts in case law to resolve the issue have either taken one side or the other, which has been the main problem with their rocky relationship. So, without outright reconciling the cases, there are some legal authorities like Lord Hope who might favour Denning's approach in Parsons to certain types of case law, whereas Baroness Hale would return to a quaint version from the Victoria case. Suffice to say, the legal system on this matter is still unresolved, and in that I would agree with McKendrick, except I would conclude slightly differently. I would conclude that there is a steady movement towards interpreting law in favour of an amalgamation of both Parsons and Victoria to form a more flexible contractual legal concept, and in doing so, end the tension between the cases. Now, that's all I have to say on the matter of breach of contract, and I do certainly hope you enjoyed this week's podcast. I will of course again be back with another edition next week, and most likely on one of the core areas of law. We've also reached that point in time where I think you're looking forward to the bibliography, which I say just because it's necessary to know the sources that have been used in this in case one wants to use them themselves. Now, I will read the sources out in full, and it is up to you whether you use them. Everything is in alphabetical order and not chronological order, so please take that to heart and memory, and it has not been grouped based on the special relationship it has to the breach of contract. Now we've got all that out of the way, here is the bibliography. So primary sources that were used include the Statute Book, Blackstone's Statute Book on Contract Law 2016 to 2017, the Statutes of the Sale of Goods Act 1979, Section 53.2, the Sale of Goods Act 1893, Section 53.2. Cases that were covered were the A/B Colsham Olifibabra and Monarch Steamship Company Limited 1959, the Gramophone Case 1909, the Johnson Higgins Limited Case 2002, Attorney General of Belize and Belize Telecommunication Limited 2009, Balfour Beauty Construction Scotland Limited and Scottish Power plc 1994, the Banque Bruxelles Lambert SA and Eagle Star Insurance Co Limited 1997, Bent's Graphics International Limited and Fashion UK Limited 1998, British Columbia Sawmill Co and Nettleship 1868, Brown and KMR Services Limited 1995, Chaplin and Hicks 1911, Corey and Thames Ironworks Company, apologies, no year for that, Hadley and Baxendale 1854, the Horn and Midland Railway Corporation 1873, Hotel Services Limited and Hilton International Hotels UK Limited 2000, Hughes and Lord Advocate 1963, Jackson and the Royal Bank of Scotland 2005, John Grimes Partnership Limited Gubbins 2013, Kufus and Kuznarkow Limited, or the Heron 2 case, 1969, Cap Profar and Woolwich Building Society, 1996, Parsons Livestock Limited and Utterly Ingam and Co. Limited, 1978, the Pilkington and Wood, 1953, Robinson and Harmon, 1848, Sally Whitheim and Chuifrin Pulp Company, 1911, Simon and Pawson and Leith Limited, 1932, Simon and London and North Western Railway Corporation, 1876, Supershield Limited and Simon's Building Technologies FE Limited, 2010, Sylvia Shipping Co. Limited and Progress Bulk Carriers Limited, or the Sylvia case, 2010, the Monarchy Steamship and Causations Lieferberg, 1949, so the same as that earlier case, the Wagon Mound case, 1961, and again 1967, Transfield Shipping Inc. and Mercator Shipping Inc., or the Achilles case, 2008, Victorian Laundry, Windsor and Newman Industries, 1949, and so concludes our primary sources. In terms of secondary sources, we have the journal by Paul C.K. Wee, Contractual Interpretation and Remoteness, 2010, Lord Hoffman's The Achilles, Custom and Practice or Foreseeability, 2010. Then we have the books, Burroughs, Limitations on Compensation, 2003, as well as his other work, Commercial Remedies, Current Issues and Problems, 2003. Burroughs, Remedies for Tort and Breach of Contract, 2004. H.B.L. Chitty on Contracts, 2012. Heart and Honour and Whistling Honour, Honore, Causation in the Law, 1959. McKendrick, Contract Law Text Cases and Materials, 7th edition, 2016. Stone and Richard, Q&A Contract Law, 2015. We also include 2 US cases, Globe Refining Co. and Lander Cotton Oil Co., 1854, as well as Jones and Van Patten, 1851. Further, we include the Singapore case, MFM Restaurants Pte. Limited and Fish and Co. Restaurants Pte. Limited, 2010. And so concludes our roundup of the references and the concluding part of this discussion. Once more, thank you for staying tuned in to our discussion. I hope we have given you all you were looking for, and that the next time you will once more receive peace of mind. Thank you for listening.